Alrighty, folks, we are live. I am George, founder of Solo and host of the Debt Hotline today. I have with us my friend John Skiba. John, can you go ahead and tell us a little bit about yourself?
Yeah, George, appreciate you having me on again. I am an attorney in the state of Arizona. My practice focuses really on consumer debt type issues. I do a lot of bankruptcy work, Chapter 7, Chapter 13, and I do a lot of representing consumers who have been sued by creditors. We deal with wage garnishment, debt collection lawsuits, debt settlement, all those kind of things. So, we do that in Arizona, and grateful for the opportunity to be here with you again.
Okay, fantastic. Always happy to have you on the show. So we're talking about specifically our little fun intro topic today is how to settle a debt collection lawsuit. So, John, what are the basics on settling a debt collection lawsuit?
Well, I mean, usually what I tell people, if you're getting sued by a creditor, if someone shows up, the process server drops off the complaint and the summons, I generally tell people you need to answer it. A written answer is typically required in most jurisdictions so that you don't end up with a default, because it becomes increasingly more difficult to settle if they already have a default judgment against you, or if they're starting wage garnishment, and all those horrible things that follow from having the default. So my recommendation is to communicate often, reach out to the plaintiff's attorney and see if it's something that you can get resolved even before an answer is due. But if not, I often will file an answer too, because of one thing is usually in most jurisdictions, they're required to provide you additional information or documentation in the form of what's called an initial disclosure about a month after after you file your answer. And that can also give you a lot of information to help give you a little more leverage, maybe to get a better overall settlement. But the main thing is taking action. You don't want to let this thing go to a default, because that's when things get really bad. And that's when they start to tell you more, pound sand, they're not going to take a lesser amount. Getting an answer filed will be a good, strong first step to getting it settled.
Okay, fantastic. Alrighty, folks. And so this is the Debt Hotline. We reserve quite a bit of time for any live questions that you have in the audience. So if you have any questions, there are a ton of people on the show watching live today on YouTube. If you have a question, just put it into the chat. We'll try our best to get to it. If we don't get to it live here on the audio, wonderful Hannah will get to it in the chat. And if you want to make sure that we get to your question, you can call into the hotline and leave us a voicemail. That's 801 613 8181. We do prioritize any calls in to the hotline at 801 613 8181. All right. And at the end of the show, we will be announcing the winner of our debt payoff giveaway. So you'll want to stay on until the end when we announce the winner for that. So we have quite a few people who have left us great voicemails. I'm going to pull up our first recording for that. Just 1 second. Alrighty. So you should be able to hear this audio recording on the voicemail. Here we go.
Hey, how are you doing? I was trying to see what would be the next step after the debt collector sends you the discovery of the charges on that debt. We went through the process and just said kind of prove it, and then now they sent back basically the discovery. And I just want to know, usually is that the time that you present a offer with them, a counter offer, or what would be knowledgeably be the next step of what we should do? Thanks.
Alrighty, thanks so much for leaving us that message. And John,
Yeah, I
what do
think
you think?
what he's talking about there is what I was mentioning before, the disclosure. So you file an answer with the court. Usually it's 20 to 40 days later, they have to provide you with their initial disclosure, which is basically where they're showing their cards. Both sides have to show any documents or evidence that they're going to use. And so it sounds like, okay, now they've got the disclosure. The question, when is the appropriate time to enter or offer a settlement proposal? I always say look through the documents, particularly if you're being sued by what we call junk debt buyers, like Midland Credit, Portfolio Recovery, companies that have purchased the debt from the original creditor. I always go through all that with a fine tooth comb, make sure that there's proper documentation, proper evidence, that they show that your account has been transferred amongst the various entities. I go through all that. I go make sure that the statute of limitations has not expired. And then I think that it's a good time to reach out with a settlement proposal. The one thing with civil lawsuits, settlement offers are not admissible in court. It's usually Rule 408 in the rules of evidence for most jurisdictions. Basically, the rules say, look, they want the parties to engage. So if you offer a settlement, it's not where they can take it back to the judge and say, hey, judge, he already offered to pay X amount. Clearly, he owes the whole thing. I say, look at what they provided, look at what you have, and then also put together what I call a settlement budget. What can you realistically afford? Can you afford some type of lump sum? Is it something where you're going to need to do a payment plan? Come up with something that's realistic for you and then propose it. The worst thing you don't want to offer something that is not realistic for your situation, because you don't want to put yourself, in a situation where it's going to be a negative thing. And also, I always say, whatever you offer, I don't care if you offer 98%, they're going to come back with 99%. So I'd say give yourself a little bit of wiggle room and when you're submitting a proposal. But yeah, that's a perfect time. After you receive that initial disclosure, that's a good time to present a settlement proposal, see where it's at. If it's something that doesn't work for you, you can continue to litigate the case as it gets closer to trial. I have often found as cases get closer to trial, a lot of the law firms that represent debt collectors are much more anxious to get it settled. They have a lot of cases. The last thing they want is another trial, and you may be able to get a deal there. But I think that's not a bad time right after you have that the initial disclosure that's been provided to you.
Yeah, that's for sure. I'll add, this is definitely a situation that we hear about frequently. And for solo, I just want to emphasize that uh, the main path for people who are coming to solo is usually settling or resolving the debt fully is the best path for you. Sometimes we have people who are coming to us where they are victims of identity theft or they're being sued by mistake. Uh, However, if somebody in that case, definitely want to don't pay money that you don't owe, right? And if you do recognize the debt that you're being sued for, we find that the best path for people is to just get that paid back and resolve it fully. With that, something that we point to is our solo steps, which is right here. So just emphasizing some of these steps to really getting out of debt and prospering. First one for people who are coming to us is respond to your lawsuit, right? If you're being sued, get the lawsuit fully resolved, and then settle your lawsuit. It's probably going to be the best option for you. And then settle any of your other debts, right? So you can settle other debts on solo as well. You can do a soft credit check your credit. Look into any other accounts that you might have. You might have like 10 or 20 other accounts that might be good candidates for settling. So you can work on getting those settled as well. Then we suggest that you make $1,000 at least
think we lost you, George, as far as the sound goes. Looks like you're trying to work on it there.
John, you want to take this one?
Yep, we can hear you now, George. Great. So, okay, so Roger says, I filed an answer to a creditor lawsuit on May 27th, no response. I sent a settlement offer through Solo, and it was counter at the amount of the claimed debt. What is my next step? So, again, the great thing you did, you filed the answer, because that buys you some time. That takes a lot of the pressure off of what you're trying to do here, because you're not running the risk of a default. Filing the answer May 27th, we're recording this on June 17th, so it's not surprising to me you haven't heard anything back. Most jurisdictions, you're looking at about a 30 to 40-day window before you're going to get your initial disclosure. But, you submitted the settlement offer through Solo's platform, which again is great. And the counter came back for the amount that was owed. Like I said, if it's something that works for you, if they came back with a payment plan or something like that, great. You can get it done and get it settled. If it's not something that works for you, or you want to get something that's at least somewhat better, somewhat discounted, you have to be okay to say, okay, we don't have it right now, or you could counter back. There usually is some back and forth that goes on before a final agreement is reached. So don't be afraid to say no, or to submit a counter, maybe that's somewhat higher than what you submitted before. If they're still not coming down, just continue on in the case until you can get a better situation. My mantra is, they want money, you're offering money. There's got to be some middle ground that can be reached. So just kind of keep moving along, and don't be discouraged just because they came back with a full offer right from the get-go.
Great. We got another question here from Tori, who's live.
All
I was
right.
paying the creditor monthly payment plan. Then last month, out of the blue, I got money pulled out of my account, $70 more, saying it was court ordered. Is that legal? Didn't receive anything prior.
That seems unusual to me. If you had a payment, well, I guess it says you're paying the creditor monthly. If it's a set payment plan with that creditor, it would be unusual for them to take more out than what they've agreed to. Depending on who the creditor is, if it's a debt collector, they could run into some FDCPA liability under the Fair Debt Collection Practices Act. You might want to double check that there's not something else out there. Because usually if money just gets pulled from account or garnished, Sometimes there's maybe a judgment out there that you may not know of. I hear literally every day in my law practice here in Arizona from people that get judgments who truly had no idea they even existed. So you may want to talk to your bank, see exactly where it was coming from. If they did pull money out of your account that's more than you authorized them normally to do, that's something where you could talk to an FDCPA attorney. I don't do that kind of stuff, but there are attorneys all over the country that handle that who may be able to help you.
Okay, great. And it looks like everyone can hear me again. So just pointing out these solo steps one more time. Come back to these, right? So our general path that we recommend for people is to respond to your lawsuit, settle other debts you have, make a $1,000 stash, like an emergency fund for you to fall back on. And then, at that point, you can really start building wealth, right? We recommend automating investments into index funds, boosting your credit score to 800 or above, and really just generally prospering from there on out. So with our solo community, we are really helping you get all the way from rock bottom, which is oftentimes being sued for a debt, and then bouncing back all the way to the top and prospering long term. That is the hope and the intent that we have for everybody who's listening in today and everyone who's coming solo. Alrighty, we have another question from a caller. So let me go ahead and plug that in here. Here we go.
Hi, question is if there's something in collections, let's say portfolio credit, like my wife has, it's something from Barclays Bank from, it shows the last payment made was 6/4/22. They haven't done any legal or anything like that, legal action. So the question is, since in New York the statute of limitation has passed, 6/4/25, they haven't done anything. What happens then? Legally, they can't go after you. What's good to do? I know we could write those letters, but they have to, show all the stuff, valid debts and this and that, and sometimes they'll take things off. But after the 3-year statute of limitations, what's a good way to go about things? Thank you.
All right, what's your take, John?
Yeah, if you know that the statute of limitations has expired, so he said in New York it's 3 years, and it does vary from state to state. Like in Arizona where I practice, it's 6 years. So if it's outside that statute of limitations period and you know that for sure, one, you need to understand that means that they can't sue you. It doesn't mean that they can't ask you to voluntarily pay it. It doesn't mean they can't call you and still be annoying and send you the snotty letters and all that kind of stuff. So they can still try to collect it, and it can still show up on your credit report. It can be a collection account for up to 7 years. So you may still have to kind of deal with it. However, the teeth that the collector has is now gone, because really, their hammer is a lawsuit. They want to sue you, get a judgment, because with a judgment, they can garnish wages, they can levy your bank account, they can lien your property. If they don't have that, one way to get it, if you want it resolved, because like in that situation, a 3-year statute's relatively short compared to others throughout the nation. It's still they could still probably, harass you for another 4 years, at least credit score wise. You could still probably try to settle it, but you have the leverage now. And to me, trying to settle a debt where the statute is expired, that's like a less than 10% offer. And I don't know if I would offer you anything more than that on somewhere the statute's expired, because it's, if they say no, then they don't really have any other options than just to kind of be annoying.
Right, nice. And right, we would say, there's still some value in paying off a debt post statute of limitations, right? As John's saying, it might make a lot of sense to get a really great deal on that. And that said, you can get them wrapped up for pretty cheap, right? Even though you can't necessarily be sued, you can still be in collections outside of court on post statutory debts, and still could make sense for a lot of people just to get those wrapped up because they want to pay back the money that they may have borrowed, and they just want to get things really wrapped up with a little bow on it. All right, we got another question here from a listener that called in. This is from Carl in North Carolina. Here we go. Here is Carl.
Yes. I need action taken for Rushmore Servicing. They're a debt collector. They're telling me that they're going to do a foreclosure on my property, and I don't understand how, if all my payments are up. I paid my city taxes last year. I paid my county taxes last year. They did not take in hand with JP Morgan Chase. They went ahead and paid it again this year. Paid my city. Then I paid my insurance. They turned around and paid my insurance again. All this is before the deadlines. And I waited a month, this last month here, and I canceled the other insurance and bought new insurance. And then they turn around and pay for that insurance again. And they telling me that, I'm in default.
What do you think?
Yeah, I mean, this is kind of different than the other types of debts that we deal with. I always say all debt is not created equal. And, if you're dealing with Rushmore Servicing, like you said, it's a mortgage loan. So it's a secured debt. There's collateral attached to it, apparently a home. When there's an issue in relation to collection on secured debts, you have to be kind of approach that differently because, if you don't pay your mortgage, if you don't pay your car payment, they have lien rights. They can come in and foreclose on the home, repossess the vehicle. So, it also depends from state to state. Some states require what's called a judicial foreclosure, where they actually go through a court process. So you'd get served just like you would like in a debt collection lawsuit. And then you could present evidence and information as far as why the foreclosure shouldn't go through. In a state like Arizona, where I live, they do it through trustee sales. So there's no judicial process. They literally sell them on the courthouse steps, like, out of a movie or something. And so when you're dealing with a mortgage like that, I think because, we're dealing with an asset, we're not dealing with a $5,000 credit card. We're dealing with an asset that's very large and that you have probably a lot invested into. I usually recommend talking to an attorney with secured debts because you may need to file a lawsuit to resolve that issue. I always say you do have in your back pocket a Chapter 13 bankruptcy. As soon as a bankruptcy case is filed, it would stop a foreclosure proceeding and give you some time to be able to try to work that issue out. But that's one where you may want to get some assistance from a lawyer, maybe a real estate or a bankruptcy attorney in your area to see exactly what's going on with the mortgage lender, because you don't want to put the home at risk, because that could cause some problems there, obviously.
Right. Yeah, you don't want to put the home at risk, right? You don't want to lose the home.
Yeah. And too much delay could cause that. So that's definitely something to take action on quickly.
Yeah. Okay. We got a live question from the audience here from that digital girl. I go to court next week with LVNV and I'm in the state of Georgia. I didn't receive a disclosure after I filed my answer. Can I use this as a defense in court? And do you have any additional tips? Thanks.
Yeah, so I mentioned before. I mean, the point of the disclosure statement is both sides have to show their cards. There's none of this Perry Mason showing up with the secret evidence or whatever, everybody has to disclose everything well in advance. That includes witnesses, documents, what their theory is, what your defense is. And so if you go into court and they have not provided you a disclosure, absolutely, I would object all over the place. If they try to introduce any evidence, if they try to call any witnesses at all, I would object. And so I've had situations like that. Usually what I do is I go into court the day of trial. Often the judge will ask if there's anything they need to take care of before we get started. And I just raise my hand and say, you know what, Judge, the plaintiff never provided us a disclosure. We don't have the names of any witnesses. I don't have any documents. So we're going to object to them admitting anything. And I bring it right up in the beginning. Now, in a situation like that, if they truly have not disclosed anything, that's a good, strong legal position to get the case actually just dismissed and dismissed with prejudice. So absolutely, that's something that you can use as a defense. Just make sure you raise that issue. Even if the judge overrules you, continue to raise it, because sometimes I run into people that want to appeal things when they actually go to trial. If you can't appeal something you didn't object to, because the Court of Appeals, their job is to look and see, did the judge make any mistakes on the rulings that he was giving you? And if you didn't raise the objection, then there's nothing really to appeal. But absolutely, that's something I would bring up, is failure to disclose is really one of the stronger defenses that you're going to have as a consumer.
Is that like a technicality, or is that a pretty grievous thing that it would actually get dismissed with prejudice?
Well, if it's at trial, so like this one, if it's at trial and they show up and they have not disclosed evidence, it's a huge thing. It's not just a technicality. I mean, it's a complete, particularly for an attorney. An attorney's going to be representing LVNB. To fail to disclose, the judge will hold them accountable, and essentially they'll tell them they can't use any of the evidence that they've brought for that date, and so they're in a situation where the plaintiff can't prove its case. If they don't disclose a witness, they can't use that witness. If they didn't disclose the bill of sale or monthly statements, they can't use it. And so in essence, they have no evidence to be able to support their case. And it's not even a dismissal. You're actually just getting judgment in favor of the defendant.
Nice. Well, glad you're up to date on your rules of evidence. Okay. So this all comes back to, folks, rules of evidence is real important stuff.
Absolutely.
Okay, let's see. We have a question from Heather. And we're going to go ahead and cue that up for us.
Hi. My question pertains to when you've had a lawsuit dismissed for debt collection because the judge granted a motion to compel arbitration, and then the plaintiff wants to refile the case. I wanted to know, is it possible to get the case removed to federal court under the Fair Arbitration Act? And if so, does Smith and Sparizzi, I think is the case name, apply to get the stay in federal court? Thank you.
All right, what is your take?
Yeah, a couple issues there. I mean, so you could file if your credit card agreement is subject to an arbitration clause. The caller is saying that they filed a motion to dismiss the lawsuit to have it heard in private arbitration. So there's these private arbitration companies, the American Arbitration Association, the other one is JAMS. There are these private companies where essentially you're renting a judge to resolve your dispute. And so if you have one of those arbitration clauses in the terms and conditions of your credit card agreement, you can ask the court to dismiss the case to allow you to pursue arbitration. Now, if the court dismisses it, it's usually without prejudice, meaning that it can be refiled again. But it's something where if you do that and then you don't pursue arbitration, either you don't or the creditor doesn't, then the creditor will be allowed to refile the lawsuit. If it's dismissed without prejudice, as long as it's within the statute of limitations, they still have time to bring that lawsuit again, even though it was already dismissed. Now, as it relates to, taking it into federal court, federal courts only have jurisdiction over cases in very limited circumstances. One, I mean, the caller mentioned, a federal statute. If there's a federal statute that is in dispute, you often see lawsuits under the Fair Debt Collection Practices Act brought in federal court, or the Fair Credit Reporting Act. Those are usually brought in federal court. Or if there's a diversity jurisdiction where the parties are from different states. Usually in cases like this, I can tell you, I don't usually do that as far as trying to push it into federal court. I usually try to actually, if the court grants the dismissal for arbitration, I will file the arbitration case, even if the creditor has not. I have found that often if you get into arbitration, the creditors want nothing to do with that, and they will often either give you a settlement proposal or even back out completely. So I think taking it into federal court might be a little more too complicated, maybe a little overkill for the situation, where just pursuing it through arbitration would be usually the better route to go there.
Alrighty, fantastic. We have another question from Erica in Virginia. Eric in Virginia here. So he wrote in ahead of time, so we're going to be reading that question for you. So Eric says, I fell behind on my payments because prior to moving to Virginia, the computer company I worked for was taken over by another after our owner died. With all of the politics, culture, and ageism involved with this transition, many, including myself, after 28 years of steady employment, found it too toxic to continue. Sorry to hear it, Eric. Sounds like a tough transition. I am presently being sued for a past debt with Upstart that was purchased by a collection company, Jefferson Capital. Suffice to say, the initial loan company closed the file and charged off this account against my wishes to work out an affordable payment plan. I had already paid $4,000 at this point. The debt was subsequently purchased by Jefferson Capital. To note, on my Experian credit report, a zero balance is associated with this account. It's interesting. How is this even possible, and what recourse do I have to once and for all settle this matter in my favor?
Yeah, I mean, Jefferson Capital, I like Jefferson Capital cases because I find that often their paperwork can be lacking. And maybe that's some of what you're dealing with there, where your credit report is showing a different balance. Those are all things I bring up in the lawsuit for a couple reasons. One, I mean, I think that, they bear the burden of proof. They've got to show not only that you had the underlying account, they've got to show how much is owed, that you breached it. And then they have the added burden of showing that it was transferred from, original creditor to Jefferson Capital. Jefferson Capital also often purchases debt from other debt buyers. So sometimes there's two or three, different companies that they have to show this unbroken chain of title. All of those things, though, can be used as evidence and things that you would want to disclose. The fact that your credit report shows a zero balance, the fact that you made payments before, you said you made $4,000 of payments on this. Often those things are not recorded accurately. Those can be the basis of doing it. So, and then not only that, but Jefferson Capital, like I said, they've got to show ownership. In my experience in litigating against Jefferson Capital, that's where a lot of their documents are somewhat vague or not really clear. And those are things to point out to the court that, look, maybe it doesn't show that your specific account was transferred between these various entities. And then the underlying to all of that is settlement. The more that you can show that you have a strong defense, the more likely it is they're going to take a lower settlement. And just being involved. We always talk about showing up is more than half the battle. In these situations, it absolutely is. Just being consistent, making sure you're showing up to court hearings, making sure you're responding to anything that they submit to the court, and then in the background trying to negotiate something. You should be able to get something resolved.
Fantastic. That sounds great. We have a live question here from Sherry. What about medical debt that sues you for not making large enough payments? Won't accept the reasonable payment plan, so they sent me to collections, and the collection company sent a summons.
Medical debt it's different pre-lawsuit. It's different how, as far as the credit reporting issues, it's different. Most medical collections, it's gonna be delinquent at least a year before they pursue it. And the fact that they filed a lawsuit, that's pretty aggressive in my experience for medical type debt. We are seeing it more and more though, where they are bringing suits over delinquent medical debts. The issue as far as like a payment plan, the creditors do not have to accept, what you're proposing. They may feel that it's more reasonable for you to pay the whole thing. Obviously, if you can't do that, then it's in this type of situation. I approach medical debt the exact same way. I do find that courts tend to be more sympathetic towards defendants in medical collections cases. They understand that, this is largely not something that was probably planned or that you intended to incur, that there's a medical issue that, obviously led to these bills. So I approach it though the same way. I do find in general that medical debt can be settled for less than maybe a typical credit card, that a lot of them are more open to that. A lot of it depends if it's been bought or sold, that kind of thing. But otherwise, I would say you treat it pretty much exactly the same way as you do like a credit card if a lawsuit's been filed.
John, it's my impression that medical debt is like no longer reported on credit reports as it once was. Is that the case? Do you know? Is that actually
You know what?
true rumor?
It's a good point, because I believe that as well. I had a case recently where I dealt with this. So where that came from, all of these kind of things actually are surprisingly political. And so what happened was, under the Consumer Financial Protection Bureau, at the end of 2024, they proposed a new rule that said that medical debt would not be reported to the credit reporting agencies like TransUnion, Equifax, Experian. However, with the new Trump administration coming in, the CFPB, the Consumer Financial Protection Bureau, is kind of on life support right now. There's questions whether that agency will even survive in its current state. That rule was revoked. So, well, I should say this: it never actually went into effect. So they can report it. However, I believe it's 120 days. It's got to be a delinquent at least 120 days before they can report it on the credit report. It might be 6 months. The bottom line is they can report, whereas under the proposed CFPB rule, they would not have been allowed to report, but now they can. So they just have to wait a longer period of time. Like a credit card, they're going to report 30 days when you're late. Medical debt, I believe it's 120 up to 180 days before they can report.
That's interesting. So the CFPB was working on that rule, but then the CFPB kind of got unplugged, and now things are a little bit in limbo.
Yeah, there was a lot of rules like that were kind of in the process. With the change of administrations, right. I think everything just got put on hold. That may be something that comes back, but at least right now, that's not accurate. They can report.
So in your experience, are most people reporting the medical debts? Or
I don't see medical providers reporting it. Like, I don't see the hospital sending these to the credit reporting agencies. But I do see collection companies, or if a debt buyer purchases it, companies that are more set up to report to the credit bureaus, they are doing it. But I don't see it. If it's staying in-house, no, I'm not seeing hospitals and medical providers doing it, because really they're not set up to do it. But like this caller said, that there is if it's with the collection company or a lawsuit or it was bought by somebody, then yeah, we are seeing it.
Right. Okay. Very interesting. Let's see. We have a question from someone who wrote in. Question from Cindy. This is Cindy in Florida. I have a debt from a car loan, and I have a payment arrangement with the bank that holds the loan. The arrangement was made through their lawyers. My financial situation has changed since I had made the payment arrangement. Am I able to renegotiate the payment arrangement for a lesser amount?
I say yes. I do it all the time. If your situation, usually it's something where you're negotiating from a payment plan to a lump sum, not something where you're just going to a lower payment or, a shorter period of time. But there's no real harm in doing it. George probably knows. Contracts, 101 in law school. Basically, the concern is that if you have a deal and then you come back with some other type of deal, that you're throwing the current deal out. I don't see that being the case. And my experience is that there is no harm in asking. If you have a $10,000 payment plan that you're paying on and you've already paid $3,000 and you come into, $5,000 going in and saying, hey, would you be willing just to call this good if I give you $5,000? I haven't seen that be an issue. And a lot of creditors would be willing to take that. They'd be willing to get this closed out sooner. My experience, though, is I've seen particularly larger debt buyers, the Midlands, the Encore Capitals, they kind of play a long game, and some of them will say, no, we'll just take the higher amount, even if it's stretched out over time. But in the end, I don't think it hurts to ask if it's something that you can do.
I suppose we're thinking that Sydney has like a deficiency auto debt that she's dealing with. Is that what we're thinking here? She has a debt from a car loan. So folks listening, it probably means that she bought a car, she defaulted on payments, the car was repossessed, the creditor sold the car at auction for less than whatever Sydney probably hoped the car was worth. And then they sued her for the difference between what the loan amount was left, or what was the balance of the loan and the amount they sold the car for at auction. That might have been like they sold the car for $5,000, balance on the loan was $7,000. They sued her for $2,000. Is that what we're thinking happened here?
That's a good point. This wouldn't be a situation where you have like just your regular car payment. You're trying to renegotiate the terms. Yeah, the car gets picked up, they sell it at auction. Any balance is still owed, that we call it the deficiency balance. In most states, there's a very limited amount of time for the creditor to actually file the lawsuit. In Arizona, where I am, it's 4 years they have to file a lawsuit. But then you could negotiate a payoff there, or a payment plan, or settle it like she's trying to do.
Right. Okay. Well, that sounds good. John, I shot you a message in the show notes here. Folks, it's now time for us to announce the winner of the giveaway. Very excited to do that. So we have a bit of a message from Hannah, who's with Solo, that I'm going to share right now.
Hey everyone, it's Hannah from Team Solo, and we are just wrapping up Solo's debt payoff giveaway. And I'm super excited to announce the winner of who will receive $4,700 to pay off towards their debt. We decided to host Solo's first ever debt payoff giveaway to celebrate our 7th anniversary as a company. And we also wanted to give someone a fresh start and a financial reset. $4,700 is the average debt amount that people get sued for on our platform. So we wanted to give someone a chance to pay off their debt and start over. So now one person is going to get to wipe that debt clean. Without further ado, let's randomly select a winner. Drum roll, please. Congratulations, Bianca Paez. You have been selected as Solo's first ever debt payoff giveaway winner. We're super excited to help you pay off your debt and help you get a financial reset. To everyone who entered the giveaway, thank you so much for doing so. This won't be the last time that we host a giveaway like this, so keep following along for more announcements about giveaways in the future, and keep working hard towards paying off your debt. Just know that Solo is rooting for you, we believe in you, and we are working hard to create solutions that will help you resolve your debts and get back on track. Thanks so much for watching, everyone, and congratulations again to Bianca for being our first ever debt payoff giveaway winner here at Solo.
Fantastic. Thank you, Hannah. And we have Bianca on a call with us here. Bianca, I'm plugging you in now. Bianca,
Yes,
can
I
you hear
can.
us?
Hi, everyone.
How's it going?
It's going.
Nice. Thanks so much for coming on the show. You're on here with me and John. How does it feel to win
I'm
$4,700?
actually in disbelief, but I'm very happy. At first, when Hannah called me and I got the call, I was just like, I was in shock. I never really won anything. So being that I won $4,700 was just a blessing for me. Um, so I'm very excited that I won.
Blessing. Glad to hear that it is a blessing for you. That is fantastic. And you won it because you're a winner, Bianca. Right? You're a winner.
Yes.
Glad to have you on the show. Glad that we are helping you out. What are you gonna do with the money?
So
You gonna go to
no.
Disneyland, or you gonna put it towards
No,
that
I'm actually
balance?
gonna pay what I owe the in order to be financially free and not have that on my back. So when I received the call, I actually felt some weight lifted from my back, knowing that I had the opportunity to pay some of my debt and finally be able to take a breather.
Fantastic. Yeah, that was great. Glad you can take a breather as well. Glad you're putting that money towards good use and paying off any debts that you owe, becoming debt free, and working towards financial freedom and prosperity.
Yes.
John, anything you want to comment on?
No, that's
Ignacio?
awesome. Congrats. That's a big chunk. Like you were saying, trying to get out of debt. It's so helpful when you have kind of a lump sum that you can negotiate with and to get things. It really just accelerates the whole process, allows you to not have any more payment plans, and so that's an awesome thing. That's a great thing. So congrats, Bianca. That'll be really great for you.
Well, thank you. I appreciate it.
Alrighty. Bianca, very glad to have you a part of the Solo community. Glad we could help you out. Folks, for those listening live, go ahead and send your good vibes and congratulations to Bianca in the chat. We got a congrats from
Thank
Tori.
you.
Congrats, Bianca. We got one from Jeff saying, yay, Bianca. Got another congrats, Bianca. Go and throw some love into the chat. And Bianca, thanks again
Thank
for coming
you.
on.
Thank you so much, Solo.
All right, John. There we go. Bianca's going to do good things with that money, I'm sure, putting that towards financial freedom. Folks, if you want us to do another giveaway, go ahead and let us know in the chat as well. We got some more congratulations to Bianca. Got one from Dragonfly Love, from Breakthrough. We have a comment from Sergeant E5. $4,700 might appease my bookie for a few days. LOL. It's a tough spot, tough love from the bookie. Okay. John, we can call that a show with one last question here just to wrap it up for one more person. Question from Tony. Do you believe that with the CFPB cuts, we will be seeing an uptick in predatory lending from collections?
I guess maybe long term it could. I largely saw that the CFPB, they did regulate and they would sanction various debt collectors. I don't know if it changed their behavior. Some of the bad actors out there, I almost think that they were viewing some of these fines and that as kind of a cost of doing business, because they would enter these consent orders, saying, hey, they're agreeing to do, not do these different things. And then 5 years later, they would be sanctioned again for doing the same thing. So, I think I can tell you, to me, one of the biggest things that the Consumer Financial Protection Bureau did, they have an awesome database of all the terms and conditions for pretty much every credit card that's ever been out there. And it's super helpful if you're doing things like wanting to see if there's an arbitration clause. You can look up your particular credit card thing right there online, and you can use that as evidence. So I don't think it'll go away completely. I mean, I think it definitely serves a role there. It's weird kind of how it was kind of formed kind of in a political manner. And so it's kind of a political football between the two parties. So it kind of goes back and forth. But overall, I don't think that it will result in any substantial change. I mean, there's other regulations. There's the Fair Debt Collection Practices Act, the Fair Credit Reporting Act. There's a lot of those things are already in place. And truthfully, legitimate debt collectors, they try to follow the rules. They're heavily regulated. That's not to say that the rules don't get broken, but in my experience, the law firms that are representing debt collectors, they're heavily regulated, and there are big sanctions when they do make mistakes. They do make mistakes sometimes, and lawyers like me, hold them to account. But it is something where there is a framework in place already to help that. The CFPB was just kind of another layer to provide some additional resources for consumers.
Okay. Yeah, fantastic. And folks, at Solo, we maintain good relationships with many of the collectors across the industry so that you don't have to, so that we can just help you get settlements and resolutions ASAP and get on your way to a debt-free, prosperous life. And really, word on the street when we talk with collectors is that nothing's really changed with the CFPB getting cut. No collector is saying, yeah, let's break all the rules now. CFPB's gone. Hooray. That's not really the case with anybody I've spoken with. They all are still pretty interested in making sure they're compliant with whatever the highest standard might be, and trying to abide by that. All right, folks. We have Jeff, who has said, of course, we want another giveaway. All right, Jeff, we have heard your voice. I'll take that into account. This is the Debt Hotline. Thanks for showing up. Until next time, take care.